So we're back. So we're finishing up page 8, number 13. So reading your comments on number 13, particularly, I mean, I guess either way. All right, so we're back.
A teacher is e-school, so 100% e-school, and they are now transitioning back to a building.
13.
I do. We do feel that the CBA with change of assignment should still stand, and they should still get that day of planning. And now they get 2 days of planning if they're changing physical school sites, but they get 1 day of planning if they're changing within the school. And so I would think that the 1 day would constitute what would be happening, because they wouldn't be transitioning to a different school site. They'd be transitioning to their school, but they do need a day of planning afforded to them. And so I guess we had some questions there too. I mean, we do this from time to time in the regular school year. So what do you do with those kids while that teacher is transitioning anyway? Isn't there a sub in place?
Well, pause for 1 second. I guess before we get to that, I think in looking at our comments on 13 and talking with everyone, the issue was we thought you were asking for additional time.
No.
So if you're only asking for the day, is that what you're asking for? The day.
Yeah, with reference in the CBA already.
Let me talk to them about it, but okay. Let me talk to them about it. I think we should be able to go with that, but let me talk to them just to make sure.
Okay.
But we thought you were asking for additional time, and I think that's why you see the comment saying we can't give extra time for teachers. So I think that's what you.
It was already built in.
Okay.
Yeah, so we were just asking for what was already built in. Okay. And then so number 15, there will be an expedited grievance procedure for all health and safety work violations to be turned around within 24 hours of the incident in question. We wanted an expedited grievance process here because if there are health and safety violations that we've already tried to address informally with principal, where they still continue to happen, we want to limit, again, exposure, and we want to keep our schools open, as long as possible. And so health and safety violations do need to be addressed pretty quickly. If we've already tried to informally address them with the site-based supervisor or principal, and when people call, we're encouraging them to have that conversation with their principal. We're having talks with principals. We're having talks with regionals if needed to be also, to get that taken care of in an informal process. But if it becomes where we see a pattern, there has to be a way to expedite this if we do have to file a grievance based on health and safety violations.
When you say turned around, do you mean met and resolved?
So yes, so that we have the grievance hearing expedited. So it's not within that, in the traditional timeline, that it would be turned around within 24 hours. Yeah.
I think that's too much for us.
So what would be?
I'll tell you why. The majority, so given that this is a unique year, I would agree. I think we need to address it quicker. And Tony, maybe you want to jump in here as well. But I think 24 hours is just a bit much for us. realistically. We're trying to manage everything in the district. And so to say that I got to drop everything and now go back, I mean, 9 times out of 10, especially if you've emailed us, we're already aware, we've already made communication with the principal or had communication with either the principal and or the regional to discuss it. And then we can get back to you. I just think 24 hours is a tight timeline for us, given everything else. And then, and I wouldn't want to agree to that and then not be able to deliver. But Tony.
Yeah, I would agree. I think that's a bit of a heavy lift, and especially if you're looking for a quality product in 24 hours. I think that's just going to be, it's going to be a little tough to do.
So would you agree to an agreement process, but what kind of time frame would you imagine?
And when you talk about expedited, can you kind of expand on that a little bit?
Sorry, that's me.
Expedited outside of the normal timeframes of the collective bargaining agreement. So we suggested 24 hours to try because of the gravity of what we're facing as quickly as possible. So we get it. I think we actually do get it that it's a huge system, and within a matter of a week, you can probably get hundreds. So what would you, since you're on the receiving end, what would you sort of think about or propose, I should say? Maybe propose not, but what's your time frame?
Pause for another second, and before he answers, and the issue with. Pause for another second before he answers. I think to Laura's point. So you're saying hold a grievance and have a disposition of a grievance back to you within 24 hours. So let's say it is at a school. I'm just going to pick on Rhonda. So let's say it's at Rhonda's school. So now she has to come down. She has to investigate further. I think that, you see what I'm saying? Like, that's a lot of steps. 8 of those hours, at least 8 of those hours, we're not there. And so if it's truly a health and safety issue, hey, Tedra was coughed on by a COVID positive person and nobody's doing anything about it. I think we just need a true threshold there to say what truly is health and safety, what is really urgent. And then 9 times out of 10, that urgent will already be resolved right when you give it to us. But to say we got to do everything within 24 hours of the incident in question, not even of receipt. So you all may have found out about it. It may have happened at 8. You all may have found out about it at 4. You give it to us at 5, and now we got to resolve it by 8 the next morning.
Right. So what seems to be evolving, just in my interaction with the emails I sent to you and to Mike, to Tony, I should say. Am I on mute?
No, you're good.
Am I good? Okay. Is that we inform you, or at least I try to inform you as quickly as possible, with as much detail as we can. We talked a little bit about that the other day. So if we have an informal process where we advise you, inform you of an incident or a situation with as much data, as much information as we can, you got it, we recorded it, that you've received it, classroom A, none of them wearing masks or something, or what have you. And then at the next level, if necessary, would be an expedited grievance process because it isn't being resolved. And at some point it becomes dangerous. So, but there has to be a process to kind of move it along. So if we dispatch an email with as best as we can, with as much information as we can to HR, says, hey, at this school, at this location, this is what's going on, it's on your plate and it's on your radar at this point, then we're going to want to sort of some kind of follow-up, right? Because we have a constituents to respond to. They'll be saying, well, what's going on, what's going on, what's going on? I'm assuming that eventually once you get to it, you look into it, you investigate, you talk to whomever, you resolve at your end, you follow up with us somehow with us. It's been resolved. We'll hear it as well. But if not, it may rise to the occasion of some sort of grievance, which we don't want to put into the normal the normal grievance timeframes. We may want to put into an expedited process, which would involve what Tedra outlined, which is statements, investigation, meeting, resolution, et cetera, et cetera. Mm-hmm. So maybe what's missing here is that we informally advise HR that X, Y, and Z is happening in this area, in this school, with these individuals, kind of put it on your radar. You go through whatever process you guys have internally when you're being advised of something like that. follow up with us at some point so that we can respond to our constituents, because if we don't respond to our constituents, they're going to demand a grievance anyway, which we have to file. So, and in some cases, they may come to us and say, hey, this is going on in this school. I don't want to file a grievance, but I do want to file a complaint, which recently just happened. I passed that on to your department. So, but we just want to kind of keep it going along. I think it makes sense for us to give you a heads up with as much detail in formally in writing, say, hey, this is going on, so that you can then process that within your department. But when you do, then we just need to follow so that we can then respond to our folks. And if it doesn't get resolved, then, Tedra, then we just file a grievance and kind of go through with it.
I guess my issue goes twofold. One is timeline, but then two, health, safety, work violations. So I think we have to be very clear about what those are. So I'm not.
You're muted, we can't hear you.
So, I guess my issue is twofold. And again, Tony, you can talk more about it, but it would be health, safety, work violations. I'd like for us to be specific there. And then the 24-hour timeline.
Yeah, I would agree that, yeah, I am unmuted. Yeah, in order for us to provide you with a high quality product, which is what you want, and you want a resolution, it's going to take us longer than 24 hours. It may take us 24 hours just to get to the bottom of what your initial concern is, and then all that information gathering that goes along with that. And so I would like to kind of put a placeholder on this so that we can kind of talk about what would be a reasonable time frame, but 24 hours isn't. Maybe 36, 48, 36 hours, a little bit longer than that,
Your last issue. With your last issue, how long did it take us to get back? Like 72?
Yeah.
So, I mean.
It wasn't a ballpark, 72 hours.
I would say 72 hours then. Yeah. And then I would say not inclusive of weekends either. So, work days, yes.
Do we want to reference health and safety work violations to things we've already talked about in this MOU, like with face coverings, cleanings, PPE, social distancing? Do we want to define it that way?
Yes, I think so, so that we all are understanding what it is that you have concerns about.
Okay. So, okay. All right. Okay. We'll work on that part and we'll bring that back. All right. So with the remainder of our time, we want to move on to page 9 and talk about the campus e-school and blended learning models of instruction, which I think are probably the biggest rest of this piece here. So we're in I guess my page 9 is different from your page 9 because the way mine printed. It's letter part B.
Page 10 of 20 for us. For assignment.
Yeah. Okay. So in number 1, we're okay with that first sentence, but we want to add in some protection for our ESP positions that they could be utilized. If they needed a remote work assignment, they could be utilized to help support eSchool. And I know that it's not necessarily their exact job description, but it keeps people with Polk County Public Schools. It keeps them as a valuable staff member, and it keeps them working. And so if they can support e-learning or contact tracing or whatever we need to keep them employed, I think we need to be thinking about creative ways to do that. And so it's not saying that they must be utilized, but they can be. If they truly need a work from home assignment, they could be utilized that way. And so we would like that part added back in.
So tell me, what are they going to do?
I mean, they could be assigned to a teacher or several teachers to help them with their 200 plus e-school students. You know, that's a lot. And hopefully those classes are being balanced out and that those numbers will be brought down. But we have e-school teachers that have 200 plus kids throughout the day. And I mean, they need some help if those classes are not going to be balanced down, which they should be. And we're of that opinion that those classes do need to be balanced, because that's crazy amount of children to have in a core class. But I mean, they could be assigned to help support several teachers in communication, maybe in their class, even to break up into small groups. I mean, again, that's not their traditional work duty assignment, but I think we have the ability to be flexible and creative here to keep people working.
Stephanie, I agree with you that to be creative, and we kind of dealt with a similar situation at Auburndale with this, and kind of going through the admin team trying to figure out what to do with some of the ESP. It's difficult to figure out other avenues that they can work. One, they all do not have laptops, and currently we've passed pretty much all of our laptops out. So trying to, and then they really have not been trained in Schoology or how to support. So you're asking them to do something that a lot of them have no idea. They haven't been trained. They haven't been formally trained. And we know that. To go all of a sudden, hey, go home on e-learning and you're going to help support this, and to be able to do that for, 8 hours a day is difficult. Can they make phone calls? Yeah, but that's not, or even if they're supporting our students with disabilities to help, but that's still not the resource teacher. So that you're still not supporting really the minutes on that. So it's just trying to come up with something creative for them to be able to do for a full work day is really difficult. I mean, my admin team, Dr. Mills and all of us, we have, tried to brainstorm for 4 weeks of how to do this. And so we still have not come up with a solution for it. And I think it's just difficult to try to do a full work day with it.
But we could train them. I mean, they may not have training now, but we could retrain certain positions to be useful to us now, so that we can
do it like on the spur of the moment.
Not necessarily.
I put you in, you got to go report, or you want to work from home, and now I've got one day to try to train you or try to get you a laptop or try to get you signed up and ready to go. It's not the best situation by any means. And trying to help with kids, and in the high school level with classes, can they support some of the math classes? Can they support a pre-calc class? It's difficult. Mm-hmm. And so that's something else you're asking them to do, is to support classes that they might not have the knowledge or the content.
Well, and I think that comes back to looking at, if they really truly need an accommodation to work from home, maybe this year they're not tied to Auburndale High School. Maybe we can look at district-wide where they can support in an area that they can. I mean, I know there's a lot of people that can't support in a pre-calc class, but they could support, maybe Auburndale Central in some capacity, if we need to figure out creative ways to move people around. Maybe they aren't tied to their school this year. I think we need to try to keep people employed as much as possible and not force them to take a leave or resign or early retire.
I'm just going to kind of piggyback on some of the things that Ty said, that in some cases content is a concern. While we could train them, the device availability, and do they have internet? Like, would we potentially be in a situation where we just don't? We've ordered a lot of devices, a lot of MiFis. They're not all here yet, and that's just a nationwide problem. And depending on what type of capacity they serve in, I have some concerns, especially if they're working with our students with disabilities or our English language learners. We're really cutting ourselves short in some of those areas where staff is already very, very limited, and that we are required to provide those supports for students. And then another thing, aside from just those instructional kind of impacts, the balancing of duties. Our ESPs are really helping us out to try to provide our teachers with a duty-free lunch, to help, supervision and different tasks on campus. And even if we were to move them around, what's Ty's backfill for his? So if I take the para that works for Ty that needs an accommodation and I move her to Auburndale Central, then I can't justify from a budget standpoint where is Ty going to get his support for whatever need she is not able or he not able to fill at Auburndale Central because we moved her around. And I think that's just the ESPs from talking about the para point of view. From talking about our school secretaries, I honestly don't know how they perform their functions from home when we have students in the building and families coming to the offices every day. That kind of continues to be my just challenge in thinking, what can we do? I mean, I think to some extent, are there some tasks you could do? Sure. Would it keep someone busy for a full day and not negatively impact the operations on the campus? That's where the struggle really happens for me because of the functions of their job.
It can't be done. I mean, let me see, I think I got this right. Okay. So if it negatively impacts your operations, right? You say it's going to really impact my operation, then the question to the answer is no, right? So the language doesn't require you. The language just offers you an opportunity because there may be something out there that where the language fits perfectly. This language, the way you're reading it, you're using the words, you're reading it as if it's required for you to do. And I don't read it that way at all. I think that if you go through the exercise and you land on, it can't be done because operationally X, Y, and Z, there's your answer. But if there's I'm sorry? It says
ESP positions can be utilized.
Can be, or should it be maybe? I mean, it doesn't.
And then is required seems a little stringent on that piece.
Where?
I circled the word can in that, ESP positions can be utilized to support if a remote work assignment is required. That's the words that to me kind of make it seem like it must when it's can and required, as opposed to words like may or shall. Like that's, I guess, I'm just sharing. That's my interpretation on that.
So I think where that's coming from, sorry, go ahead.
So I think my issue here is twofold. One is the language that says an accommodation for comorbidities is required because of an ADA accommodation for comorbidities with COVID-19. To me, that means that you're trying to, the language will circumvent the fact that it may be an undue hardship on the district for them to be out. And so the issue is, practically speaking, and I've shared this with you before, the other bargaining unit employees generally were okay. The ones that we had the most issue with when we left for March or whenever that was for fourth quarter, we generally had a problem with we generally had a problem with our ESP employees because they felt that the B day, the work from home day, they were out. They were at wherever and they weren't doing any work. So that means that they didn't make any phone calls. They weren't tied to, any deliveries. We couldn't get them to even answer phones at home. And so it was, no, I don't want my cell phone to be, you can't call my cell phone. This is my B day. And then when we did ask them, hey, can you go to the campus for this? And it didn't happen all the time, but it happened quite frequently. When we did ask them to go to the campus for this, well, I live 30 minutes away, but you do realize we're paying you for this day. And so that is the frustration. And so we can't continue to do that. I just, and then the other thing you talked about is earlier, you said something about us being creative. I think there's a misconception out there, and maybe a false narrative out there that the ADA committee is not being creative. And I think that's the farthest thing from the truth. As I said earlier, you look at job duties, you look at the job description, and everybody in there is thinking, how can we accommodate? The answer isn't a default no, it's usually a default yes, but is that going to be an undue hardship? That's the line and the thinking that we go through. And if it is an undue hardship, meaning I'm going to have to now replace Ty's person because his front office person is out on an ADA accommodation, but what is she going to do from home? She can only make so many calls. She or he can only make so many phone calls, right? She can't do any of the, they don't have computers, so they can't do any of the other tracking, right? So it just, you look at it from a, what can they do? And then on top of that, if I move her to another position, look on our website, we don't have that many ESP positions. We just don't. That's not, it's not something we have a lot of. It's not like it's a para position or even a teaching position where we can maybe move people around, but you can't do that with ESPs. And so I think it's incorrect to say that one, we're not being creative or not, and I think it's inaccurate. Maybe that's a better term. I think it's inaccurate to say that we're not being creative. But then too, I need you to think, and I need you to look at it organizationally. How can a secretary really work from home? What, and then how are their duties now going to be passed on to other people to do? So if it's one secretary's out at school, then what else is going to happen? Who else is going to manage the front office? What's going to happen there with those front office people? You're going to really create a divisiveness there amongst the front office staff, because now I got to do Laura's job and my job too. I don't get paid enough for this, is what they say. Realistically, right? And so, so I think we just have to think about that when we're proposing language like this. But to Wilfredo's point, this language doesn't say what you're saying like at all.
Well, so
Tedra, I may not be the norm of an employee, but from March, okay, when I was informed by my supervisor that she had nothing for me to do, I went and found some work to do. I had Dana contact Mike to see if I could take some paperwork from her division for me to have work to do. So there are employees out there. You all, this is all based on the bad scenario. Can we not also look at that there are good ESPs that,
I'm sorry. Let me say this, Althea. I'm not saying that all ESP are bad. As I've shared with Stephanie, as I've shared with Stephanie earlier, the employees that we had a lot of issues from in terms of getting things done on campus were our ESP employees. And so you're right. I would say that I would applaud you for what you are doing and for what you did in terms of volunteering. We didn't have a lot of that across the district. We had orders being literally left out and because doors weren't being answered, because nobody's answering the phone. So we had a lot of issues with just front office staff working from home. And that's not a knock to ESP. It's just kind of what it was and what it is.
With good language.
Oh, yeah. Sorry. Go ahead.
My computer got
quarantine.
So, yeah, I just wanted to mention, again, that wasn't the intent, I think, of what Tedra was saying. It's the amount of work. And one thing we have to keep in mind is we cannot pay someone for not working. And we got away with that in some way, shape, and form last year, and it cannot happen again. So I just want to throw that out, that there's a state statute that you cannot pay somebody for work that they didn't do.
But I think, Mike, I think that becomes a supervision issue, because if if the supervisor is aware that employee is, to go to an earlier example, is shopping instead of working, right? What have you, then that's about supervising correctly, right? Supervising. So I get what happened early in the year. Listen, it was crazy, but I think that, again, if the employee needs to be working, but is that supermarket is whatever, and the supervisor is aware of it, rather than complain about it, that he or she is within the right to address this process. So we shouldn't throw away what could be possibly good language, tweak it, because perhaps some supervision didn't occur in a timely fashion.
And I agree with that. I think we're just saying that sometimes it's hard to get a person on an accommodation 40 hours of work, whether they you just can't get them to work.
Right, I don't disagree. So, because the answer is because financially you can't, it's the hardship gets detailed in it, then the answer is always going to be no. You know, I mean, I agree.
So let's table this for now so we can try to get the rest of this heard. So with B2, I'm hearing feedback. Okay, thank you. Okay. So with B2, we're okay with, I mean, that, I don't see this process happening or being changed at this point. So with B2A, family was taken out, but it's addressed below. And so should it read, first consideration will be given to qualified instructional employees approved by the ADA Review Committee for an alternate accommodation to their traditional work style due to age and/or an underlying medical condition, which may place them at a higher risk to contract COVID-19? It seemed like it just kind of stopped. Like that sentence wasn't finished. Because you took out the actual age in your comments, you took out the age, like the specific age restriction, but then it didn't get finished out. So I wanted to make sure we added that back in so that it finished out the sentence. You see what I'm talking about, Laura?
Yeah, I do. You see our comments?
I think my comment though below, maybe if you look at 45, district owns ADA process. District owns ADA process. And so I'm unsure. I think I had a question overall. I didn't strike it, but it should have been stricken with 2A and 2A1. This is not bargainable. And so as the ADA committee, that's not something that's a bargainable issue. That's what we're trying to figure out. Like, why is this in here?
Go ahead. The ADA.
So hold on for 1 second, and then it's just 6. Right, 44 and 45. So can I ask? Go ahead. If you want to address something else.
Yeah.
It's 6:15. I just want to make sure that everybody.
It's right here. We're talking about the. So you have your.
Yeah.
You got it?
First consideration at the beginning?
Yeah. Okay. And then they deleted that. So that's your.
Okay, yeah.
So the ADA process should be interactive though. And right now it's not really being interactive with the employee asking for the accommodation. And so that's, yeah.
So, and some of this process is going to work. And really, you know, we have a class action grievance in the process. We have an information, we just got some of the information requested returned to us. We'll go through it. to be perfectly honest, when folks are filling out the ADA forms and there seems to be some space with
You're muted, Wilfredo.
Okay.
Yeah, I can hear you.
All right. So I noticed in the notes it said that this is a specific management rights. We obviously disagree with that because there are significant portions of the ADA process that are subject to negotiations, at least a conversation with the union. If it has an impact on terms and conditions of employment, especially when it comes to accommodations, that's a conversation that needs to happen with us, with the union. Now, the issue around this is that when folks began to fill out the forms, the ADA forms, that seemed to be a natural process, at least the beginning part of it. And then there was some real serious dead space in between the filling it out and then the denial. No one could really get the hands of what does the process really kind of look like? Who are members of this committee? How are they reviewing it? What do I need to do in terms of making my case in front of this committee? So it was all over the map. So folks are kind of chiming in at a significant rate to us. We attempted a few times to reach out to the committee, either by phone or email, say, can you connect with us? I need to know what this is about so I can convey the message correctly. I even personally made a couple of calls myself and I never got responses to. So, the ADA review committee, however it processes it, I think that people are entitled to know what's the process, what do I need to bring to this process, am I entitled to an advocate to this process, if so, how, if not, why. I'm pretty sure that they are entitled to, once the employer says, to take an example over here, that it's an undue hardship, I think that they are entitled to then come back to say to the employer, well, here's some alternatives to your undue hardship, how we can get the job done. And that process, only until recently, am I seeing one or two emails that say that they actually reach out to the member and say, what's your solution to get the essential function of the job done? Because the initial flood of emails, maybe flood isn't the right word, but a lot of emails that were sent out, there were denials, basically say, you've been denied, here, appeal it. Well, that leaves this real vagueness, serious vagueness in their minds, and I can't figure it out either because we don't have the information. What you articulated in the beginning portion of this session, that's closer to a process that we were looking for, that our members, that employees were looking for in terms of what is this ADA appeals process, who's in it, and how do I kind of state my case there, even if it's in an individual basis. So that's why we wanted to negotiate a process, because we really didn't know there was a process there. By the way, you should know, you may or may not know this, but it looks like we have a first set of emails that simply say you are denied. There seems to be a second set of emails that say you are denied, appeal it here. And now the latest version is a set of emails that say you're denied, appeal it here, and state your case. And I'm paraphrasing. So there seems to be 3 sets of emails that have gone out, and that even made it worse. So how do you resolve that problem with someone who you've denied accommodation, and maybe you said financially we can't pull it off, but they're being left out and can't come back to you and say, well, here's some alternatives I want the employer to consider, which, by the way, I'm pretty sure that they're entitled to do, and you're entitled to consider and respond to. So, but that's sort of the genesis of what kind of brings us to where we are right now.
Okay. So a few things. One, the ADA process has never changed.
All right, go, sorry.
So the ADA process is. So the ADA process has never changed. It's always been in place. And so it is essentially the same process that we have had for years upon years upon years. This process has been scrubbed several times. Chris Laney, I was just say wasn't Chris, the legal department approved it. Don sits on it, Don Wilson. And so this is a process that we've just utilized. Not only that, I know that other districts are utilizing the same ADA process to handle COVID accommodations. So I think I am a bit unclear or maybe unsure in terms of what you're talking about with the change of the process. There is not necessarily a change of a process. It's still just the same process, number one. Number two, I know I've seen the communication regarding the class action appeal, and I actually saw the one from Orange as well, so I'm not sure. I guess I'm guessing that that is something that is being pushed maybe by FEA and statewide regarding the ADA accommodation appeals and the, or ADA accommodation class action grievances for the denials based on COVID. So I'm guessing that's something that's being pushed by FEA. But nonetheless, my point about this is for us, it has never been bargained. That process has been in place. And that's not something that at this time we are willing to bargain. So we can give you the information that you requested or whatever that is, but this whole subsection A is not something that at this point we're willing to bargain. So.
Well, the team will have to agree to this. I mean, the way I see
subsection A, right, and again, the committee will have to agree to this. This language shouldn't be an impediment to achieving agreement in this MOU, because I think that we have other venues for remedy, whether it's the grievance and arbitration process or the EEOC process. So it shouldn't be an impediment to it. However, that being said, please note that, Tedra, you may be correct that this committee may be around a long time and been vetted by your attorneys, but this process is a mystery to the bulk of your employees, and they're entitled, even if it's on a one-on-one basis, to go to the employer and say, I hear you, financially you can get it done. Here's some suggestions on how we can get the accommodation done, right? I think that they can do that. But anyway, my point is that I think subsection A shouldn't be an impediment to an agreement if we because there are other venues to kind of resolve the matter, whether it's EOC or grievance and arbitration.
So I would agree with you wholeheartedly. I don't believe that anything would prevent an employee from coming to us, hence why you have the COVID appeals ADA or COVID ADA appeals email. We've received several communications from employees about appealing their denial via that email. And so we've talked to several employees about it. In fact, Linda and I talked today. She said, hey, Tedra, can you call this group and I'll call this group? Yes, Linda. And so I'm not debating with you regarding the fact that employees have a way to appeal should they want to.
And so I do want to add.
I'm sorry. I'm looking at the time. It's 6:25. What about section B? I thought you wanted to speak to something specifically. You said that this was the majority of the.
Yes, so this was the majority of it. So we can come back, but I did want to point out really quickly that only AI was our addition. A and B under B2 was your language that it was originally proposed. We had only added in the I section about the ADA appeals process.
Okay, well, maybe then that's why I struck that part.
Yeah.
Okay.
Okay, I just want to point that out. So we wanted to look at if we can jump to number 5 and number 6, in the campus e-school model. I did want to, so on 5A, we agreed to campus e-school will be maintained at school averages for class size. We agreed to that last time. Therefore striking the district's proposed class size, because we've agreed to school, so that can go away. You have stricken through part B, which is the instructional delivery requirements, but that is agreed to in the pre-planning MOU. So we were confused as to why that was stricken when we agreed to the instructional delivery requirements in the pre-planning MOU. 5B. Yes, campus e-school model. Some of it, yes, and we'll address that. But so in the merge document, we had that B was the instructional delivery. So I think some things got maybe moved over in different spots in the original merge document from the comments that Laura had sent us on Monday. So we wanted to keep the instructional delivery requirements that we had agreed to in pre-planning. That was teachers will choose from a mix of live stream lessons, recorded lessons, and both synchronous and asynchronous discussions. Just as in a face-to-face classroom, best practices such as whole group instruction, small group instruction, checks for understanding, feedback cycles between teacher and student, and independent practice should occur in segments of a class rather than an entire block of instruction. It's number 9 in the pre-planning MOU. In the original merge document that I sent over on August 17th, when I merged both our proposals.
Right. My question is where that.
That's what I'm saying. I think that it got.
Oh, okay.
You see what I'm saying? That's what I was just pointing that out. That yeah. Okay. So we wanted that added back in as part B. Yes, B as in boy. Okay. We're okay with striking C, which was students will only be permitted to participate in live video as long as they turn in their stuff. And again, that was an eloquent summary of that. We're okay with striking that C. And D during instructional time. So C and D, we're okay with that. Now what we are not okay with, and after reading the ICP again, even the ICP references the CBA and other subsequent MOUs that could be addressed. And I think that, again, for peace of mind, they should cross-reference each other. And so we are still firmly in the belief that E, teachers will assign working grades as they normally would in campus learning. F, and that this is from original because things have been moved around from the comments one. Teachers and support staff will be available for parent guardian contact only during non-student contact time and during their normal duty day. So that one, and there's more to that, but I'm just having you find it. G, any lesson plan requests will follow the approved lesson in the approved language in the CBA. And that's actually already stated. So, I mean, we could even get rid of G since it's already stated in lesson plans later on. For H, where video content will not be used by the district for any purpose or exhibited in any other context without written permission of the bargaining unit employee, we want to keep that sentence, but we're okay with striking the other 2 sentences at the bottom of that from your comments. And we think we can merge H and I together.
Can you go back to video content? What do you agree?
Say that again.
I don't think you agree to on video content.
So we're okay with the first sentence. We're okay with striking the other 2. If that's from reading your comments, that seemed to be what you guys were had most angst about. So we want to keep the first sentence though. So video content will not be used by the district for any purpose or exhibited in any other context without the written permission of the bargaining unit employee. We want to keep that and possibly merge that with I. Well, I guess this is your new F. Sorry, the letters are different. That no person shall record a bargaining unit employee without their knowledge or permission or risk of being subject to discipline according to the district's disciplinary plan and or legal action. And that's also citing Florida statute. So we would like to keep that. And so merging E and F together to make it one letter. So people are not allowed to record other people without their knowledge. It is, but specifically with eSchool, and honestly, I think the peace of mind is particularly with parents and or students in an eSchool setting recording without the teacher's knowledge. It is a fear of people's. And if we can reiterate what the law says, that they're protected under that, I think it would bring people peace of mind.
What's the difference, like during a regular classroom, if the kid finds out that the teacher's not doing appropriately?
The teacher's not, it's not talking about different teachers.
It doesn't say that.
No person shall record. I mean, kids shouldn't be recording, parents shouldn't be recording, other staff shouldn't be recording people without their knowledge.
But if it's like a regular brick and mortar school, and something is being said in class, or we use it.
It's not.
If it's like, if you're kind of like being unethical and doing something, towards a child that's being recorded in a classroom, we hold that again, like, we use it. But that's, I think we had the same conversation last time about that.
We're including it in these circumstances.
Can't hear whoever's talking.
And when disciplinary action is being considered, video recording will not be used. We're okay with striking that. That was the conversation we had last time. In I, which is now F, that's not saying that. That's saying that people should not be recording other people. And that if they are recording other people, so even let's say Ty and Laura are in a class, right? And Stephanie's the teacher, and Ty records me and I'm doing something I shouldn't be doing, I could be subject to disciplinary procedures. But Ty, because he recorded me without permission, could also be in trouble because he recorded somebody without permission. That doesn't negate the disciplinary action that I might be held to. And that's why we were okay with striking that language in what was letter E. But Ty should also be held responsible because he recorded without somebody's knowledge. And we're not, even in the cell phone policy for the district, you're not allowed to do that. And so we want that reiterated here in an e-learning setting. Does that make sense? That's what F is saying.
I understand. It just seems like it contradicts. Like, it seems like you could take one side, one section, and then you didn't like that, you could go to a different section. It doesn't seem clear. It seems like there's two different comments in it.
I'm afraid of. I'm afraid of.
It's about that.
That's what that's saying.
Can I ask you something, Stephanie? If it's already stated in state statute, why do we have to put it in a bargain thing if it's already written somewhere else that it's against the law? That's what's kind of getting me. For example, if we've already got it in the CBA, why would we put it here? If we've already got it in a state statute that you can be prosecuted for this, why would we put it in a bargain thing that you can already get prosecuted for?
Well, it's pretty, oh, sorry, go ahead. I mean, we recite CBA articles in Florida statute and CBA. I mean, that's a common practice where in the CBA, you'll find the Florida statute, right? You'll, you know, in MOUs, we have CBA recitals that specifically address what we're trying to talk about here. And so we felt that this was appropriate to put in here in this e-learning model, that this still applies. And hey, here's a statute that says you're covered here. So that's the intent behind this.
But like Kyle said, we had this discussion, and MOUs are not for that purpose. MOUs are to cover anything that is not covered in a statute or a code of conduct or an ICP or the CBA language. So it's redundant.
See, I would disagree because we recite CBA articles all the time in MOUs. I mean, all the time. We have CBA articles recited or cited all the time.
MOUs are created to handle any situation that is not covered under a CBA.
I mean, but even to that point, even in your proposed language, let me get it out. In your proposed language, even when you talk about lesson plans, on your original proposal in page 6, you say lesson plans, all provisions in teacher article 6.9 regarding lesson plans remain in place. I mean, that was from your proposal initially. I mean, that's a common practice to, if there's something specific in the CBA that addresses what we're talking about in an MOU.
To yours, so that was a compromise. You said we'll just say that because you had something else different from us.
What page is that?
No, we didn't.
Thank you.
Well, I think regardless.
I'm looking at 43. I think this is really a bit embellished. So what I would rather do is, do you have any other changes to this section that you need us, that you want us to talk, or that you want to share with us today? And then we'll go from there. All right. I can honestly say I think to Ty's point earlier, this is not, your intent is not being expressed here with this language. But go ahead, is there anything else in 5 or 6? Peaceful model.
Just to go back with what was stricken through, which was the merged document EF with the working grades, and that teacher and support staff will be available for parent and guardian. I mean, we want that in there. So in yours on the screen it's C, and I go back up.
Right, so you've already communicated that with us. Okay. Is there anything else in this e-school model that you need to communicate?
On your E, if you go down to E, which was the old J, E, it's if student is consistently failing to complete assignments and or has failing grade, teachers will reasonably attempt. Okay. So it seemed like the conversation in the comments was that there seemed to be an issue with teachers will not be required to use their personal phone. It's not saying that they couldn't if they wanted to, that a supervisor cannot make them use a personal phone, because they can use Jive through their computer. You know, if they have their computer, they don't have to use their personal equipment if they don't want to. Now, as a teacher that loved Remind, I use my personal phone because it was easier for me. This is not restricting the teachers' use if they want to. This is restricting a principal saying that they have to use a personal device. And so we wanted to clarify that point because that seemed to be the angst in the comments. So it's not saying that the teacher can't or the support personnel can't. It's that it cannot be required of them, because they do have other avenues that they can use if they want, that are district supported platforms like Jive, etc.
At this point, it's 42. We will be out. Is there, what other dates are you available? I don't know if anybody else would agree. I would propose that we just do it on Wednesdays. I think it's a good time for everybody, particularly on our side. So we do Wednesday at 8.
I mean, I think our side would like to get this wrapped up sooner rather than later than waiting a week.
I don't know that. I mean, with school being in session, I don't know that that's really feasible, particularly with everything on everybody's plate.
I think that's where the frustration I think is coming in on our side too. I mean, we all know we're busy and everybody in our team is willing to stay until this is done tonight so we can just get it done.
I think that's the thing, but know that there are several other districts that don't have an MOU in place. And so we're not saying that we're not willing to meet.
Wouldn't you rather be a leader in getting the MOU finished and done than saying there are several other districts that haven't gotten theirs done, so we're just following along? I would think that having the MOU complete would be a feather in your cap to.
Excuse me if I may. I think we all need to realize, got a lot of feedback there, so if somebody could mute. I think we all need to realize that we're all working tirelessly. We're all putting forth the effort. Yes, we're all invested in completing the MOU. We're working in good faith together. And I think at this point, we need to take, I think we need to just realize that we're all working diligently to do the best we can with this monumental task of starting the school year. And we're going to have to work together. And from my perspective and our perspective, that's what we're here doing. And so, yes, we appreciate and are willing to work in good faith. But I don't hear anybody saying we're not interested in being leaders or interested in trying to work through this. We certainly are. Obviously, we have points of disagreement that we're going to have to still talk through and work through. But at this point, I think we all can agree that we are working together to do what's best for our school district, to do what's best for our students, our school-based staff, and our district as a whole.
I mean, I can do next Wednesday, but I am also free. I mean, we can do Friday afternoon too, to see if we can get this done. I mean, I think Wednesday, because we're going to have to move into salary talks anyway. I think having Wednesdays as a standing meeting is a good idea until we get salaries done. But I think that we might want to look at Friday this week to see if we can get this MOU done. And then we can move into salaries, because that's going to be a whole other can of worms with the teacher salary allocation.
So let me talk to Monday later. I'll email you tomorrow about Friday.
Okay.
But as of right now, let's do Wednesday.
Well, I think putting Wednesday on the books is a good idea just in general, because we can, by Wednesday, we'll be ready to bring a salary proposal to the table too.
Yeah, I thought you all were bringing it today.
Angela was on vacation this week, and I had a few other questions to finalize up with her. And I also had emailed Heather Jenkins and JD Mike when we got the information in July, and it's just been crazy. And I sat down this week to do my pivot tables. We're missing the para and ESP levels. So we have their pay grade, like we know that they're in PA 1, but I don't know what experience level they are in the new data. And so we got that data in March before COVID happened, but we need updated data. I was able to do and disaggregate the teacher levels, but I do not have the current levels for experience levels for the para and the ESP contracts.
I'm not sure that Heather and JD and not Hedges area.
Yeah.
Okay.
But we'll have to.
Okay. Okay. All right. Okay. Yeah. And I'll do that with you tomorrow, Laura. I'll get that with you. And so we had a few questions about who had, because we needed to see who was incoming and like the level 1 and maybe who left and to update it. And then I had a few more questions for Angela on the teacher side. But then we'll have that ready for you guys next week.
I just asked a question, are we still working the 80-20 or we're good with the 80%? We're just dealing with 20?
So I think we still, based on our talks from previous, we still want to try to do the bands and set it out that way. We think that's going to be the most equitable. But we can talk about that formally. And we'll get you those beforehand so you can see them beforehand.
But you do realize no other district is doing agreements, right? Everybody's only doing their own negotiating.
Well, when I talked to Osceola, he was not in agreement with what the district's trying to propose, and that's not a done deal. Or not Osceola, and Seminole. So I know Mike had sent me over Seminole's district proposal, but they're still going back and forth. And Lair Allen, their president's with me. We're trying to do the bands. And so nothing's been settled in Osceola. I did say it right, Osceola, not Seminole. Seminole's in a different situation. They had agreed to a 2-year before the teacher salary allocation even came out. So they're trying to do something completely different than all of us because they had a 2-year salary agreement, whereas everybody else had a 1 year and they were coming back.
Okay, so we'll get the financing ready.
Yeah.
And then we'll go from there.
So we'll bring that on Wednesday too.
So you have it next week, then you want to present that first?
I think, honestly, I think we've got to get through this
Trying
first.
to figure out, I don't need the whole team here, if you're going to present salaries and talk about salaries first.
Well, I mean, if that is better for your team, but I think we need to make sure that we have time allocated to just get this done on Wednesday then.
You can present anything you like. I'm trying to make sure that the whole team isn't here. So we've never had principals to come to the financial side of it. It's just been normally you and Mike and everybody else.
But we're not going to just do, so they would be coming later?
That's what I'm trying to figure out.
Okay.
So
We can do that first if that's better for your principals. It doesn't matter to me.
What's the plan? That's what I'm asking.
To get the MOU done first.
Yeah.
And then move on to the next. Yeah.
And you're just going to present salaries, just pushing across the table?
I mean, however you guys want to talk about that, we can have a collaborative conversation here. I'll even give it to you guys before we meet on Wednesday if you guys want to take a look at it beforehand. I'm okay with that. Mike, if that's your pleasure.
That's fine.
Okay. Okay.
Okay, so then now back to the reopening MOU. Do you have any other comments or anything that we need to review before Wednesday? Can you email those to us so then we can go ahead and look at those and figure out what we can do prior to Wednesday?
Yeah, I'll talk to my team and then we'll do that so we're ready to have a discussion. And please, if we can, we're willing to make Friday work. So if you can let me know tomorrow, that would be great. All right.
Okay, thank you.
All right, thanks guys.